President, please be seated. The court is back in session, and the floor is given to the co-prosecutors. Mr. President, Your Honors, everyone in and around the courtroom. It is now the thematic session on grounds of the OCP appealed, and we have heard the responses from the Khieu Samphan defense team. And I would like now to raise my remarks regarding the sentencing against the accused. Could you hear me, Mr. President?
Okay.
As Your Honors are aware, the trial chamber held that the maximum sentence that the ECCC may impose, sentences of life imprisonment, most appropriately sanctions the criminal conduct of each of the accused. The co-prosecutors entirely agree, and we ask this chamber to confirm the sentences of life imprisonment. I will first briefly address why life imprisonment is the most appropriate sentence for the two accused before responding to the arguments Khieu Samphan raised on appeal in relation to his sentence. As the chamber held in case 001 and as followed by the trial chamber in the case 002/01 judgment, the primary factor to be weighed at sentencing is the gravity of the convicted person's crimes. Nguyen Jie and Khieu Samphan have been convicted in case 002/01 of the crimes against humanity of extermination encompassing murder, political persecution, and other inhuman acts comprising forced transfer, attacks against human dignity, and enforced disappearances. These are extremely grave crimes in and of themselves, and Nguyen Jie and Khieu Samphan perpetrated them on a broad scale. The trial chamber found that at least 250 Lon Nol officials were murdered at Tuol Po Chray, and a minimum of 2,330,000 to 2,430,000 people were victims of crimes committed during the first two phases of the forced population movement. As the trial chamber rightly noted, the number of victims is among the highest of any decided case concerning international crimes. Adding to this gravity, these crimes were committed across large portions of Cambodia and have had a lasting impact on direct victims, their families, friends, and loved ones, and indeed on the entire nation of Cambodia up to and including present day. The gravity of the crimes is further exacerbated by the circumstances in which they were perpetrated. The fact that many of the victims were particularly vulnerable, including infants, children, the elderly, sick and injured people evacuated from hospitals and pregnant women who had just given birth. Moreover, the involvement of both Nuon Chea and Khieu Samphan in perpetrating these crimes was extensive and substantial. Nuon Chea and Khieu Samphan were among the relatively small group most responsible for the development of the policies that led to these crimes. Your Honors, the judgment properly referred to them as key actors in the formation of the policies. The evidence amply shows that they knew the crimes would be committed and were involved in implementing them throughout the period encompassed by case 002/01. The evidence demonstrates that Nuon Chea was, along with Pol Pot, the ultimate decision maker within the CPK and within the DK regime as it implemented these policies. He was Deputy Secretary of the party and a member of the Standing Committee. The evidence also demonstrates that Khieu Samphan was a candidate member and later a full rights member of the Central Committee, a frequent attendee at the Standing Committee meetings, and a trusted confidant of Pol Pot. He disseminated, endorsed, and defended the common purpose and policies. He provided encouragement and support to the CPK and utilized his trusted and respected character in that endeavor, thereby facilitating the accomplishment of the crimes and implemented key economic aspects of the common purpose. Both Nuon Chea and Khieu Samphan abused their positions of authority and influence to accomplish these crimes, and both Nuon Chea and Khieu Samphan were highly educated and well understood the importance and consequences of their actions. In comparison to this, no mitigating circumstances significant enough to overcome these factors are extant in relation to their individual. Nuon Chea has not challenged his sentence on appeal. May Supreme Court Chamber uphold TC decision. Khieu Samphan, however, alleged that the trial chamber committed errors in reaching its determination that a life sentence is appropriate for his crimes. He asks that this chamber impose a fixed-term sentence, but does not identify what mixed-term sentence is requesting. He is requesting, rather. As we addressed in our response brief to Khieu Samphan's appeal, we submit that the arguments Khieu Samphan raises have no merit and should be dismissed. Khieu Samphan argues that the trial chamber held that he had no actual authority. Khieu Samphan argues that therefore he must have played a limited role in the commission of the crimes and is not deserving of a life sentence. However, Khieu Samphan misrepresents the judgment's findings in this regard. While the judgment finds that some of the positions that Khieu Samphan formerly held, such as Deputy Prime Minister, Minister of National Defense, and General Staff of GRUNC, and President of the State Presidium in 1976, had limited authority. That does not mean that they were not significant. Judgment notes that along with Hu Yun and Hu Nam, Khieu Samphan was the public face of the opposition movement, and through his public statements ordering execution of 7 traitors of Lon Nol regime, Khieu Samphan played an important role in bolstering the legitimacy of the movement. Nor did the trial chamber find that Khieu Samphan had a limited role in the CPK itself. Indeed, to the contrary, as already mentioned, the trial chamber found that Khieu Samphan was a candidate member of the Central Committee since 1973 and made a full rights member in 1976. He was a frequent and contributing attendee at standing committee meetings, a leading member of Office 870, and had significant supervisory responsibilities in regards to the Commerce Committee, warehouses, and power factories, among other formal and informal roles. These were the positions of authority that he abused, and it was in these capacities that the trial chamber found that Khieu Samphan made a significant contribution to the joint criminal enterprise and planned, instigated, aided, and abetted the crimes at issue. As such, the trial chamber found he was a key actor in formulating the policies that led to the crimes, knew the crimes would be committed pursuant to those policies, and that his involvement was extensively and substantial. Khieu Samphan's arguments that he played a limited role in relation to these crimes are therefore meritless. These arguments simply evade his criminal responsibility. Khieu Samphan also argues that his level of education, which the trial chamber found was aggravating factor for sentencing, has never been contemplated in international law or Cambodian law as an aggravating factor. This is demonstrably false. For instance, the ICTY trial chamber in Branchonin at paragraph 1114 of their judgment held that the accused was an intelligent, university-educated person who knew exactly the import and consequences of his actions. The trial chamber finds that these facts constitute an aggravating factor. As with Brajanin, the fact that Khieu Samphan was highly educated shows that he was fully able to grasp the nature of his acts and understand their consequences. Khieu Samphan also argues that the trial chamber erroneously disregarded evidence of his good character. Mr. President, Your Honors, the trial chamber did not disregard the evidence that Khieu Samphan put forward in this regard. Indeed, it considered it and found that Khieu Samphan may have been kind to people in specific instances. However, the trial chamber rightfully found that these isolated instances cannot play any significant part in mitigating crimes of the severity of those for which Khieu Samphan has been found guilty. To the extent that any of the mitigating factors have some limited merit, they are vastly outweighed by the gravity of the crimes and the aggravating circumstances. Similar to this chamber's finding in case 001, the outstanding aggravating elements and exceptional magnitude of the crimes for which Khieu Samphan has been convicted neutralize the limited impact of these mitigating factors. Furthermore, this chamber also noted in case 001 that at the international level, a line of appeal judgments from the ad hoc tribunals confirms that life imprisonment can stand in spite of mitigating factors where the gravity of the crimes so dictates. Finally, we note that even if Your Honors found some part of Khieu Samphan's argument regarding his sentence persuasive, it should not be amend the sentence of the trial chamber. This chamber has itself noted the deference that it affords to the trial chamber's determination of sentence, and that the party seeking to have a sentence revised carries a substantial burden in that regard. In the case 001 appeal judgment, this chamber, quoting a decision of the ICTY Appeals Chamber, held that the trial chambers are vested with a broad discretion in determining the appropriate sentence, including the determination of the weights given to mitigating or aggravating circumstances. As a general rule, the appeal chamber will not revise a sentence unless the trial chamber has committed a discernible error in exercising its discretion or has failed to follow the applicable law. Your Honors, we submit that the trial chamber has not committed any errors in these regards, and in any event, Khieu Samphan has failed to carry his burden so demonstrating. We therefore ask that this chamber affirm the life sentences imposed on Nuon Chea and Khieu Samphan by the trial chamber as the only sentences that are proportional to their crimes and that accurately reflects their culpability. Thank you, Mr. President, and Your Honors.
President, I now move to the appeal of the co-prosecutors, which is our last semantic session, and I'd like to hand the floor now to the co-rapporteur to present the report. Judge Momani Jariya, thank you, Mr. President. I'd like now to present the report on the co-prosecutor's appeal. The co-prosecutors filed an appeal in case 002/01. They request that the Supreme Court chamber finds that the mode of liability referred to as the third or extended form of joint criminal enterprise, also known as JCE3, is applicable in proceedings before the ECCC. Both the pretrial and trial chambers previously found that JCE3 was not part of customary international law at the time crimes were alleged to have been committed and therefore not under the jurisdiction of the ECCC. In the trial judgment, the trial chamber recalled these decisions and on that basis decided not to consider JCE3 any further. Instead, Nunchi and Kia Sampon were convicted for the crimes charged based on the other modes of liability. The co-prosecutor's appeal raises, first of all, a question as to its admissibility. With their appeal, the co-prosecutors do not seek a change to the dispositive part of the trial judgment, as they do not allege any error that would invalidate it. Nevertheless, they submit that the Supreme Court chamber has the power to admit legal errors of general significance to the jurisprudence, even if those errors do not have any impact on the decision under review. The co-prosecutors submit that this is a self-standing basis for admissibility of appeals, well established in the international procedural rules and operates independently from ordinary review of errors of law under Internal Rule 104. The co-prosecutors note that Internal Rule 105.3 refers to an alleged error in validating the decision, but not the judgment. The co-prosecutors also refer to jurisprudence of the ad hoc tribunals, which in their submission supports their position. The co-prosecutors aver that the Supreme Court chamber is the apex judicial body of the ECCC and should have the opportunity to address compelling issues of law, even if they would not affect the ultimate judgment, noting that the ECCC agreement and the ECCC law do not provide interlocutory appeals as foreseen under Cambodian law. Finally, they invoked what they described as compelling considerations of international public policy in support of a review by the Supreme Court chamber. As to the substance of their appeal, the co-prosecutors submit that the trial chamber erred when it found that JCE3 did not form part of customary international law at the time of the crimes and therefore was inapplicable in ECCC proceedings. They submit in particular that post-World War II case law indicates that this form of liability was firmly entrenched in customary law and that the pre-trial chamber's analysis of the case law was tainted by error. The co-prosecutors request that the Supreme Court chamber correct this error by declaring that JCE3 is indeed applicable in the proceedings before the ECCC. Thank you, Mr. President. President, I'd like now to hand the floor to the co-prosecutors to make their submission.
Thank you, Mr. President, and Your Honors. I think it would make sense to begin my presentation by answering the question that you asked relative to our appeal on this section, question 5, which asks whether the criminal responsibility based on this extended form of joint criminal enterprise would include only crimes that the perpetrator actually foresaw, or also those that were merely foreseeable. I'd like to answer that by citing some of the jurisprudence that already exists about the extended form of joint criminal enterprise, or JCE3. One of the cases where that extended form was utilized was the appeal judgment in Stockage at paragraph 65, the appeals chamber of the ICTY held that the accused can be found to have third category JC liability if he intended to further the common purpose of the joint criminal enterprise, and the crime was a natural and foreseeable consequence of that common purpose. In other words, liability attaches if, under the circumstances of the case, first, it was foreseeable that such a crime might be perpetrated by one or other members of the group, and second, the accused willingly took that risk. The crime must be shown to have been foreseeable to the accused in particular. And the Stockage Appeal judgment cited Kavachka and Tadic. We agree with that. In Kavachka, paragraph 86 of the appeal judgment, they held that what is natural and foreseeable to one person participating in this case, in their case, a systematic joint criminal enterprise, might not be natural and foreseeable to another, depending on the information available to them. In the Tadic appeal judgment at paragraph 220, talking about the third form of joint criminal enterprise, they held that what is required is a state of mind in which a person, although he did not intend to bring about a certain result, was aware that the actions of the group were most likely to lead to that result, but nevertheless willingly took that risk. In other words, the so-called dolus eventualis is required. In Karadzic, there was litigation before that trial began. I mentioned this yesterday about what the third form of joint criminal enterprise, exactly how it should be defined. In the trial chamber decision, 28 April 2009, again, they mentioned that in determining what an accused foresaw, it might be relevant to take into account what was foreseeable to any reasonable person in his position. So that, I think, summarizes what our view is. This is, JC3 is a form of dolus eventualis, in that it holds that when someone joins a group with a common purpose, intending to commit crimes within the jurisdiction of the court, to the extent that there are other possible crimes that their co-participants could commit that are foreseeable to the accused, and he nevertheless accepts that risk and continues his participation, then he should be held responsible. In the appeal chamber decision in Karadzic on this issue, where the defense challenged whether JC3 should require a probability as opposed to a mere possibility, in paragraph 8, the appeals chamber held that after reviewing jurisprudence, they say this convincingly demonstrates that JC3 mens rea does not require a probability that a crime would be committed. It is, however, worth noting that the term possibility standard is not satisfied by implausibly remote scenarios. Plotted on a spectrum of likelihood, the JC3 mens rea standard does not require an understanding that a deviatory crime would probably be committed. It does, however, require that the possibility that a crime would be committed is sufficiently substantial as to be foreseeable to an accused. So that's exactly what we are advocating and what we are saying was part of customary international law in 1975. That if anything, the jurisprudence of the ad hoc tribunals since that time has simply further defined the elements to the benefit of the accused to make it clear what is required in the mens rea and the actus reus. I think you could even add an additional qualification. I think this is implicit in this jurisprudence, that the criminal plan, the common purpose that is criminal, has to increase the risk that this possible crime be committed. And let me give some concrete examples of exactly why this is an issue of importance and how practically the position of the prosecution and the defense differ. And the defense, Q Sampan's defense, can correct me if I'm wrong about their position. What we are saying is that when people agree to commit a crime, intentionally commit a crime, such as forcibly deporting people or persecuting a group, torturing individuals, giving orders or plans to kill people, and other crimes are a foreseeable possible consequence in the circumstances, they should be held responsible. Defense, as I understand, is saying, well, if it wasn't his intent, they shouldn't be held responsible. A concrete example. We know that in the facts of the cases in this court and in many other conflicts, there were orders to groups to persecute groups of individuals, to sometimes torture, or to kill. So, for example, in many of the German cases, even in the Eisen group, and cases where groups of Jews and other minorities were targeted for killings, there also were laws and instructions that soldiers, Germans, could not have sex with Jews. And yet the evidence, the historical evidence, is that many rapes occurred when groups of soldiers were given women to go take away and execute. And the same facts will appear in the circumstances of the cases in Cambodia. So, for example, about 2 weeks ago, a woman named Ahmed Sophia testified in this courtroom and talked about how a group of Cham women and girls were taken to a house, and all those who identified themselves as Cham, were taken outside, taken to a pit where she witnessed their execution. She also said she heard some of them say, "Please don't rape me." We know that much of the evidence in the case shows that often before executions, probably for reasons of saving clothing, the victims were ordered to disrobe before the executions. Now, is it foreseeable when you give militia members, including teenage boys, every opportunity to enslave workers for years, to persecute groups, to sometimes to torture in detention women, or to execute them, that in those circumstances, even if they're told that the Khmer Rouge policy is against rape, that they will in fact sexually assault them? We say absolutely in the circumstances, and that'll be of course a matter for whatever trial chamber hears any such case to determine, but we will say that it's certainly possible where a trial chamber finds that that's a possible consequence foreseeable to an accused. In our submission, the law should hold them responsible. It's a foreseeable consequence of the criminal plan that they have, where they have willingly taken that risk. And as I said, we believe that this is rooted, as our appeal brief points out, in the jurisprudence going back to the Second World War. If you look at the plannings for the Nuremberg, particularly the Nuremberg Tribunal, there was a UN War Crimes Commission formed, which began to meet in 1983 with the purpose of advising states on the law to be applied in any subsequent trials. In their report of March 1945, and this is Authority 36 that we provided for the appeal hearings, they had examined English, Soviet, French, and the Czechoslovakian systems of criminal law, and they pointed out it is a common principle to all four systems of law that if, quote, several persons act together in pursuance of a common intent, every act done in furtherance of it by any one of them is, in law, done by all. In their report on holding members of the German government responsible, they said such individuals, quote, must be held responsible like members of a group of wrongdoers for all criminal acts according to the principle that every act done in furtherance of the criminal purpose by any one of them is in law done by all. And if we look at the statutes that were then established for the Nuremberg and the Tokyo tribunals, we see again there is the intent to hold all of those that play a significant role in a criminal plan responsible for all the actions of the members of the group. The Nuremberg Charter and the Tokyo Charter, I believe, have identical language, quote, leaders, organizers, instigators, and accomplices participating in the formulation or execution of a common plan or conspiracy to commit any of the foregoing crimes are responsible for all acts performed by any persons in execution of such plan. Control Council Law Number 10, which was subsequently set up to try those slightly smaller fish after the Nuremberg Tribunal finished, provided that any person is deemed to have committed a crime who, quote, was connected with plans or enterprises involving its commission. What we are now advocating is adopting the jurisprudence that's been developed, articulating this principle since the ICTY began, since Tadic, which actually only has further defined it to the benefit of the accused by making it clear what mens rea is required. They must actually foresee the crime and accept the risk, and their contribution has to be a substantial contribution to the criminal enterprise. It's consistent with how the Control Council Law 10 judge advocate in the Martin Weiss case described the common design. He said, all who join in such common design to commit an unlawful act must take responsibility for all the consequences of the execution of the act if done in furtherance of the plan, although not specifically contemplated by the parties, or even if forbidden by the defendant, or although the actual perpetrator is not identified. And I know counsel has questioned the value to be placed on the Control Council Law Number 10 cases. This has been reviewed and challenged by other parties in other cases, and the law is quite clear. One case is Erdemovich appeal judgment. This is actually from Casasi's dissenting opinion. He says Control Council Number 10 can be regarded as an international agreement among the four occupying powers. The actions of the courts established or acting under that law acquires an international relevance. So in the cases that we've cited, just broadly, what they often show is that, for example, in cases where groups of prisoners were taken with a common plan where it's clear that individuals in the group agreed to their mistreatment. Under the Geneva Conventions, you can't use prisoners for propaganda purposes, and you certainly cannot assault them. And if in that mistreatment they were subsequently killed, all were held responsible for the killing when the trial chambers found that that was a foreseeable result of the criminal plan. And I think another very good example cited in our brief involves the actual judgment of the IMT and how it was applied to those who were involved in the slave labor program, particularly Sokol and Speer. And what the case seems to hold clearly to us is that those who were involved in procuring individuals as slave labor, even if they didn't want them to be further mistreated, assaulted, or killed, or starved, they were held responsible for it as a foreseeable result of that criminal plan. and that they had continued to participate in that plan while accepting that risk. Now, the defense makes a point in both defense teams in their briefs that often in both the Control Council Law number 10 and in the IMT judgment, the accused are found guilty of broad categories, basically war crimes or crimes against humanity, without the courts often articulating exactly which of the crimes it is that they are convicting the defendant for, which of the abuses. We think that's just a further example that the law at that time was that when you were participating in the criminal plan, you were held responsible for all of the consequences. The courts didn't feel a need to identify particular crimes, individual crimes that the person was responsible for. But many of the decisions make it absolutely clear that they were in fact finding the people guilty of the unintended but foreseeable crimes. So for example, in Eisengruppen, they made it clear that murder was the principal charge in that case. And they held people like Poole responsible even if they had indicated that they were opposed to mistreatment of Jews or burning downs of synagogues. They were still convicted of the war crimes and crimes against humanity that where the principal charge was murder. Similarly, for Speer and Sokol, if they were not being held responsible for these abuses of the slave labor program, there would have been no reason for the court to have mentioned the fact that they said that they were against it, but they knew it was happening. So by indicating that, it's clear that the courts were extending their liability for crimes that were foreseeable to them. Now, I just want to briefly mention the logic of the appeal chamber and pretrial chamber and trial chamber. The pretrial chamber found that the joint criminal enterprise could be severed. We think you have to take that principle as a whole, but they said severed, and that the third form, this extended form, was not part of customary international law, and that to apply it to the accused would violate the legality principle, specifically the nulle crimen sin lege, that you cannot punish a person for a crime without law. But if you look at that principle, it's something that's absolutely fundamental that everyone in this audience could understand. It's the basic principle of fairness, that if your conduct at the time, there's no reason for you to know that there's anything wrong with it. There's no reason for you to know it's illegal. You cannot later pass a law and say, oh, now we've decided that your conduct is illegal and we're going to punish you for it. But it's focused on the conduct. What is the difference between the third extended form of joint criminal enterprise and the first two? Well, the second one is even more ambiguous because the second form also includes foreseeable results. A person who just is part of a systematic system of mistreatment and knows that crimes are happening. They're held responsible for crimes future crimes if they continue to participate. But in all of these, what's necessary for the third form of joint criminal enterprise and the first is that a person has the intent to commit a crime within the jurisdiction of this tribunal, in this case, and that they make an intentional and significant contribution to the joint criminal enterprise. So there's no way that this principle of protecting innocent conduct can be said to be violated when you say, well, yes, I knew that deporting millions of people from a city was against international law, but I didn't intend for them to be killed or raped. Now, that is not innocent conduct. That's clear. The principle of nulle crimen sin lege cannot be violated because this is clearly conduct that has been made illegal. The person has both an unlawful mens rea, a guilty mens rea, a culpable mens rea, and has made an action, a significant contribution to the joint criminal enterprise. So in our view, it does not make any sense to apply that principle of nulle crimen sin lege to then excuse those who have committed acts, intentional acts violating crimes against humanity or war crimes, and say, well, we're only going to hold you responsible for the crimes you intended, and we're going to excuse you from those that you could foresee and willingly accepted the risk would occur. That violates, in our view, the fundamental principles of justice and the purpose of the nulle crimen law, which is that justice be served. So thank you, Your Honors.
President, thank you. So now it is a good time for lunch. And the chamber will resume the hearing at 1:30 p.m. Security personnel are instructed to bring the accused to the waiting room and have him returned into the courtroom before 13:30. The court is now in recess.